Unacademy. Let's crack it.
Good evening to all of you. In the last class, we have discussed about Article 19. And under Article 19, we have just discussed about the scope. The nature, already we have discussed. The scope, under the meaning of a scope, we discussed that freedom of speech and expression includes, firstly, that is right to information. Secondly, it includes right to know the antecedents of the candidates. Thirdly, it includes right to maintain silence. Fourthly, it includes about the freedom of press. And fifthly, it includes the freedom of exhibition of the films. And after that, we need to understand that, as I told you, that the freedom of speech and expression is not absolute right. Therefore, there are many restrictions on Article 19, which is mentioned in Article 19, Clause 2. So today we will talk about the restrictions. Restrictions will not take for me more than 2 minutes to tell you that what are the restrictions, but we will take different case studies. For example, we will talk about firstly that internet suspension. Many of the times you might have read in the newspaper that there is a crackdown of internet. 2 days back also it was reported in some of the districts. Then how this internet shutdown or the crackdown is happening, whether it is against Article 19 or not. If yes, then how it is happening. Then secondly, the tapping of phone, that is many the times you might have read somewhere that the phones of the government officers, phones of the MLA, MPs have been tapped. Then what are the rules for the tapping, that I will tell you. And then I will interrelate it with the different elements on the basis of which freedom of speech and expression is limited. Then I will discuss about the second case study, that is the rising hate speech, and how the hate speech is the kind of, you can say, restrictions on the freedom of speech and expression, because you have the right to speak whatever comes in your mind, but it should not be hate speech. So obviously we need to understand that what is hate speech, what is the understanding of the Supreme Court on the idea of the hate speech. That thirdly, I will discuss with you about the very famous case, that is Shreya Singhal case. And then you will understand that why I am talking about all these case studies under the meaning of 19 clause 2. And then I will discuss about the law of defamation. Firstly, what is defamation, and then what's the law of defamation, and then how Article 19 is applicable, that is the 19 clause 2 is applicable. So these all are reasonable restrictions. These all are reasonable restrictions, not the restrictions. So whenever I say reasonable restrictions, then what do you mean by reasonableness? So we will take the help of Anuradha Bhasin case, that is the case of the scrapping of the status of Jammu and Kashmir and giving the status of the Union Territory. After that, this case was filed in the Supreme Court, because then the government has suspended the services, that is the internet services in Jammu and Kashmir. Then many of the petitioners went to the court highlighting that it is against their freedom of speech and expression. So basically, I will take the help of many case studies that is happening around us, and we will try to integrate it with the meaning of Article 19 clause 2. Because whenever the question will come in the mains examination, if you are not aware about the case study, then you cannot write even a single line. So just knowing the restrictions by reading the book or somewhere, it is not going to work now. And also you can see that for the 4 or 5 years, last 4 and 5 years, if you will see the question is the analytical. But analytical doesn't mean that the question is from current affairs. The questions are not from current affairs. And today we will do 2 mains question, and then we will do 10 to 11 prelims question also. So the 2 mains question that I will give you is from the PYQ, and you will understand that after knowing all this, it's all about the understanding of your static part and mixing it with the current affairs part. So now, firstly, Article 19 clause 2. What is Article 19 clause 2? As I told you, under 19 clause 2, there is a mentioning of restrictions on freedom of speech and expression. The first restriction is the security of state. Security of state. Second is sovereignty and integrity of India. Third is public order. Fourth is incitement to an offense. Incitement to an offense. Then the next one is decency and morality. Decency and morality. Then defamation. Then contempt of court. Contempt of court. Then friendly relation with foreign states. Friendly relation with foreign state. So these are the elements on the basis of which freedom of speech and expression is restricted. So I am clubbing the first three together, or you can say the first four together. And then I will talk in little bit of detail about the defamation. Then contempt of court I will not discuss, because under Article 129 and 215, I need to discuss contempt of court in detail in the chapter of judiciary. And friendly relation with the foreign states, how it is related to the restrictions on freedom of speech and expression, that I will relate. So as I told you, that the different case study that I will pick is first hate speech, second FOAC in cyber age, then internet crackdown and tapping of phone. So these three things are related to the sovereignty, security, public order, and friendly relation with the foreign states. Now picking up the very first one, that is the internet crackdown and the tapping of the phone. So you all are aware that the phones can be tapped. So any phone can be tapped. The point here is that when the phone is being tapped, then it is against the freedom of speech and expression, because you are always in the fear that the communication device that you are using is under the surveillance of the state. The same thing I told you, that the laptops that you are using, the computer that you are using, it can be easily scanned by the law enforcement authorities, because Section 69 of the IT Act gives this power to the law agencies to look into your computer, to decrypt the computer. Now, whenever the tapping of the phone, or whenever the question of the tapping of phone arises, then recently the famous IPS officer from Maharashtra, she was in controversy. But however, it is not a very new thing that she has tapped the phone. So the tapping of the phone is continuously since from 1990. Even the former Prime Minister VP Singh has said that his phone is being tapped. So the Prime Minister's phone is being tapped, then what about the other MPs, what about the other MLAs, and what about the other officers, I can say. Recent news is with respect to use of Pegasus software. So use of Pegasus virus. So the opposition parties were telling that the ruling parties are inducting Pegasus in the mobile phone, and that Pegasus software is a kind of virus that is decrypting the information that you are sharing with someone. Whenever you are calling someone, then also that Pegasus software is recording that what information you are giving to the another person. So this is a kind of invasion of the freedom of speech and expression, because once you are in fear, then you will not say anything on the phone. And therefore, if you will have any friend, अगर है तो अच्छी बात, नहीं तो बाद में बनेंगे, if you will have any friend from the bureaucracy, until and unless they are not very close to you, very matlab very close, they will not give you any call. On normal call, they will never give you. If you want to talk to them, they will always call on WhatsApp. Every time. They will never call on a normal call. You can't expect from the civil servant. It's very simple that they know that the phone can be recorded. So recording of the phone is also a kind of invasion of the freedom of speech and expression, because you are not aware of that your phones are being recorded by someone. Now, these are the things with respect to the tapping of the phone. Now, whenever I am talking about the internet crackdown, so whenever in the district there is a problem of law and order, whenever there is a chances of law and order problem, or whenever at the time of the examination also nowadays, because conducting the exam is a very big task in India now. So at the time of examination also, fear of cheating and all, the internet services are being cracked down in a district or near the examination centers where the examination is going on. Likewise, Jammu and Kashmir also, that after this revocation of the special status of Jammu and Kashmir, the internet has been suspended not for 1 day, not for 2 days, but for more than 6 months. So all these things are taking the fundamental right of yours, that is the freedom of speech and expression. But now the question arises that if the government is doing all this, then obviously the person, that is the individual, will go into the court. That the government is also aware of. It's not like that the government is not aware of that you will not go to the court. Government is ready with that you will go to the court, and the government have the answer for that in the court. Now, as I told you in the very first class of the fundamental rights, that your fundamental right can be taken as per the law, So these things, that is internet crackdown, tapping of the phone, is being done as per former Indian Telegraph Act 1885, section 5, clause 2. However, this act has been repealed, and now we have the new act that is called as Telecom Act 2023. So it doesn't mean that in this Telecom Act 2023 that was passed just 3 or 4 months back do not have that particular provision. Even this act have the same provision, and this provision says that whenever the government feels that because of the internet, because of the use of phone, there can be threat to the security of India, sovereignty and integrity of India, public order and friendly relation with the foreign state, and any incitement to an offense. These all words are written in this Telecom Act 2023 now. It means that whenever you will sue the government into the court, the government will say that this is my right to crack down the internet, this is my right to tap the phone, because in this particular law, all these words are clearly written. And therefore, the government, by using that particular provisions of the law, is tapping your phone or shutting down the internet in your area. So legally, they are not wrong. That is another thing, that what should be the intensity of putting a ban on the use of internet. What are the rules for tapping of the phone? That's the another thing. But the very first instance, we have understood that the government is not wrong. Government have the power to do all these because it is written in the law. If this word should not have been written in the law, then the government would have been wrong. But if these words are mentioned in the law, then the government is right. This is the first thing. Now what has happened, that if you will see 10 to 12 years back, I am talking about the story of 2000 and 2010. At that time, it was very easy to tap the phone of any individual. Very easy. If someone is in IB, if someone is in any of the intelligence agencies, we have 16 different intelligence agencies in India. So if anybody is functioning or working under these intelligence agencies, then they can easily put your phone on surveillance. But this matter was highlighted in the Supreme Court and PUDR versus Union of India. And the Supreme Court has said that this is very arbitrary. I am not telling that you should not tap the phone. Yes, it is very important to tap the phone because of the security of the state, sovereignty and integrity of India, the chances of public disorder, and the chances of incitement to an offense. This is very important, but there must be certain rules for tapping down the phone. And the rules that has been created after the Supreme Court recommendation was, or is, you can say now, that the Secretary to the Ministry of Home Affairs will give you a letter. He will have to send you the letter, that is through the email. Either he can send through the email or he will send you the official letter. And in that letter, he will allow you for the tapping of the phone. Then only you can put the particular phone on surveillance. For example, intelligence agencies, that is IB, wants to put the phone of some individual on surveillance. Then they will have to take the permission of the Secretary of the Ministry of Home Department. Then only they can do. But what happens sometimes, that whenever the IB officers are on the field, then it is very difficult to take the permission within a minute, and within a minute the IB officers will have to put the phone on surveillance. But that time, what is the procedure is, IB officers, without asking to the Ministry of Home Affairs, can put the phone on surveillance, but at the same time they will have to send email to the ministry, that is the Ministry of Home Affairs Secretary. Then Secretary will answer it within 10 days that yes, continue the surveillance or don't continue the surveillance. This is the rule. And at the same time, the ministry, that is the Ministry of Home Affairs, will take every month, there will be a meeting. In that meeting, all the intelligence agencies will sit. They will see that how much telephone is on surveillance, that is how much mobile phone is on surveillance, and then is there any necessity to continue its surveillance? If yes, then continue, otherwise downgrade that. So this is the rule that has been set by the Supreme Court, and that is inserted as per the Indian Telegraph Act, and today that is the Telecom Act 2023. So this is the rule. Now the second one, that is the freedom of speech and expression in cyber is. Now there was a very famous provisions in IT Act, that is section 66A of IT Act. And section 66A of IT Act states that if you are sending any information via any communication device, and if that information is misleading information, for example, whenever I say misleading information, it means that many the times you are receiving an email, for example, that just by the opening line of that email, it seems to you that the Prime Minister Modi has himself sent you the email, but it is a kind of fake messages that is being sent to you. Sometimes unsolicited links are being sent to you via email or via any communication device just to mislead you. तुम्हें लगता है कि बहुत इंपॉर्टेंट मैसेज आया है, जस्ट बाय रीडिंग डाउन द फर्स्ट पॉइंट एंड द फर्स्ट ब्लॉक में जो लिख के भेजते हैं, दैट इज द कैपिटल लेटर्स में, तो जस्ट टू अट्रैक्ट यू, just for your attraction, so that you can open that. जब तुम उसको open करते हो, then you find that it is a very misleading information. There is nothing in that. So whenever you are sending such information, or whenever you are sending information that may create anger in you, that may create hatred in you. For example, if you are sending information to someone, then it may create hatred in that person against you. It may create a kind of anger in that person. It have the chances of creating enmity between you and that person, anything like that, then the punishment was directly jail. So what has happened, that you might have, whenever you will, I think that you will be in school at that time. So two lady from the Maharashtra, I don't remember the district. So two lady, that is the young lady, has said something and about the Bala Sahab ji. So Bal Sahab Thackeray, he has said something about him, and then the police has sent him to the jail. The same thing has happened with the Yadavpur University professor. So Jadavpur University professor has said something about the Chief Minister of West Bengal. So he was also sent to the jail. The same thing has happened with Taslima Nasreen. So she is in India and she has also said something about again the same thing, that is the CM of the West Bengal. Then she was also sent to the jail. It means that whenever you are sending any information, then it is being considered that it is against the government. Whenever you are telling anything about the government or about the particular person of the government, then it is being considered as against the government. So what you are doing, that you are sending the person into the jail. Then in the famous Shreya Singhal case, the matter went to the court. And the court has said that I will just see that whether these particular words are written in section 66A of IT Act or not. But as I said you, that in the section 66A of IT Act, it is written that if you are sending any messages or any information that has the potential to create enmity, hatred, anger, then these three words are not written anywhere. These three words are not written anywhere. And therefore, the Delhi High Court has said, and later on the Supreme Court has said, that now section 66A seems to us unconstitutional. Because the section 66A of IT Act is not protected as per the provisions of 19 clause 2. So if you will compare the Indian Telegraph Act with the section 66A of IT Act, then you can feel the difference. Because as I told you, that in the Indian Telegraph Act and today in the Telecom Act, it is clearly written that on these basis the internet can be suspended, on these basis the phone can be tapped. But these things are not written in section 66A of IT Act. And therefore, the Shreya Singhal case is a very landmark judgment that you must remember. Because in this particular case, the Supreme Court has declared this law as unconstitutional. Not the complete law, only section 66A of IT Act as unconstitutional. But unfortunately, these things has happened in 2016-17. But again, this matter came into the news because in some parts of the country, police officers are not aware that section 66A has been declared unconstitutional. And they have booked 11 persons on the basis of section 66A of IT Act. Then again, the matter went to the Supreme Court. Supreme Court has said that 5 years back, I have declared this provision as unconstitutional. Then how you can book the person under the same provision? Police officer said, sir, I was not aware of that. But Delhi is far away from us. And therefore, whatever the verdict you have given in Delhi, that has not reached to us. And therefore, we have booked the person under section 66A of IT Act. Then the Supreme Court again advised to the government that I have declared it unconstitutional. You repeal that provision. Then only they will get to know that now there is no any section 66A. Because once the Supreme Court says that section 66A is unconstitutional, it doesn't mean कि वो वहां से तुरंत ऑटोमेटिकली अलाउद्दीन का कुछ आता है और वो डिलीट हो जाता है. ऐसा कुछ नहीं होता. वो वहां के वहीं पर वहीं रखा हुआ है वो. The only thing that the Supreme Court has said that it is unconstitutional, but they are not aware of, and therefore they were booking the person under this particular law. Now, hate speech. What do you mean by hate speech? Well, is the hate speech defined in India? So, there is no any definition in any of the law with respect to the hate speech. And therefore, the Supreme Court has defined the hate speech in Pravasi Bhallai Sangathan case. And in this case, the Supreme Court has said that we look at the hate speech. समझने की कोशिश करना. There are two groups. Groups have not been created, but it has been created. So there are two groups, that is one group and the second group. So whenever the hate speech I will have to define, then I will have to define based on your membership of the group. It means that if you belong to this group, then you will speak something that is against that particular group. It means that if you will see this particular analogy in the terms of religion, if you will see this particular analogy in the terms of caste, it means that if you belong to a particular religion, then you are making the speech in such a way that you want to show that the members from that particular group that is opposite to your religion are inferior, and you want to put your hegemony on them. The same thing. That is, if you are belonging to a particular caste, then again you will make a speech. That intention of your speech is to delegitimize that particular group that is against your caste. And this is called as hate speech. Now, hate speech has become very popular in India. And it has become much more popular when the media persons have started investing their energy in hate speech. And in Amish Devgan case, Amish Devgan was booked under this particular hate speech for propagating the hate speech. And the Supreme Court has said that whenever any matter of the hate speech will come, then we will see it from three different parameters. First, what is the content of the speech? The second that I will see, what is the intent of the speech? And the third that I will see, what is the harm that a speech can occur or that a speech can result against the another group. These three parameters, on these three parameters I will see, and then I will decide that yes, the person should be booked under the hate speech. But now the question arises, if the hate speech is not defined in India, then how we can book the person for the hate speech? For this, there are many provisions in the IPC. For example, the very first provision is section 153A, the second one is 153C, and the last one is section 295A. These are the three provisions in the IPC that brings us near to the idea of the hate speech. For example, section 153A of the IPC says that you will be booked if you are creating enmity between the groups. So if you are telling anything that results into some sort of enmity between the two different groups, then section 153A will be applicable. Just like that, section 153C says that if you are telling any speech, if you are making any speech that is prejudicial to the national interest, then also you will be booked. Section 295A says that if you are telling anything against a particular religion, that is, your speech is directed very particular. This particular provision is very particular, that is with respect to the religion. So if you will compare section 153A bit to 95A, then you will find that 295A is with respect to religion and 153A is with respect to anything that can create enmity between the groups. If you are telling against the women is also one member. Women is also a member of one group. And then if you are telling something against the women, then also it will be considered that is the hate speech. But at that time, section 295A will not be slapped against you. Section 153A will be slapped against you. The same thing on the basis of the caste. So this is the idea of the hate speech. Now, what is the problem with the hate speech? बोल दिया. What's the problem with the hate speech? Sentiments तो बहुत जल्दी हट हो जाता है. Sentiments और emotion एक ऐसा चीज है जो बात में हट हो जा रहा है. So, for example, and I will bring you from this discussion to one of the important case, that is Bradenburg versus Ohio case, that is in the case of Anubhav versus Union of India in India. So in this case, what has happened, for example, if I am coming to this class and I am telling something कि बहुत ज़्यादा inequality हो गया है, there is too much poverty, there is too much inequality, and the bourgeois class is taking all of our resources and we are left with nothing, ये सब बोल के मैं चला गया. Now, what you people are doing, then after that, you have started picking down that who is bourgeois class from this class, and then you started doing violence. Then I am responsible for that or not? I am responsible for that or not? No. How I can be responsible? I have not said you to do the violence. You are doing this. It means that the imminent lawless action test will be applicable by the court on this matter. And the court will see that whatever I have spoken, what's my intention was. So my intention was not that you should create violence. Maybe my intention was just to make you aware that there is a divide between the rich and the poor. I just want to make you aware. But tum zyada hi aware ho gaye and then you do the violence. Then I am not responsible for that. This is called as imminent lawless action. Matlab lawless. Matlab there is a lesser law. Matlab there is a deterioration in the law and order. So the court will look into that whether it is imminent or not. How likely my speech has resulted into the damage in the society. This is called as imminent lawless action. So from this discussion, we have also understood that whenever you are speaking something with respect to the hate speech, if I will apply, so whenever I am speaking something then there may be that my intention was not to create the enmity. It's that you people have created the enmity. I have not created enmity. So that the court will apply this test on my speech. And if the court again finds that no, my speech was or having the potential to create enmity, then only I will be booked and then only I will be sent to the jail. So these are the different tests, these are the different case study, these are the different Supreme Court case you will have to understand in order for the application of the freedom of speech and expression and its restriction under Article 19 Clause 2. Now, I was asking you about the impacts of hate speech. So what is the impact of hate speech? As he has rightly said, that it is against the idea of the fraternity, that is the core value of our preamble. Uske saath saath, tell me. Communal violence, mob lynching, good. Very good. That is called polarization. So the very first thing, ऐसे नहीं सोचा जाता है. मैं सोचने का तरीका बताता हूँ. I am just telling you that how you should think. All the points are correct, but I am telling you one more thing that you should apply whenever you are thinking anything. That is called as pestle analysis. So just think from the perspective of political, P, E economical, S social, T technological, L legal, and E environmental. Pestle analysis. So if someone is asking anything to you, just apply this logic, pestle analysis, and think from this perspective. Now, for example, the very first, that is the political manipulation. So whenever the leaders at the time of campaigning are giving the hate speech, their intention is for the polarization. Polarization on the basis of religion, polarization on the basis of the caste. So hate speech have the potential to create vitality in the atmosphere, that is in the political atmosphere. The second thing, that is the social. So whenever I am talking about the social impact, then it is impacting the cohesiveness of the society. That is, it is impacting the harmony, that is, it is impacting the fraternity in the society. That is the social impact of the hate speech. What is the economic impact of the hate speech? Economic impact that you can see, that wherever there will be a problem of law and order, the investor will never invest in that state. So the same thing, you can see the difference between the different states. So why there is too much investment in Gujarat? Why there is too much investment in Tamil Nadu, in Kerala, in Haryana? So in all these states, if you will see, then there is the best law and order. There is no any problem of law and order. But again, if you will see the Bihar, UP, then you can understand that there is a problem of law and order, the very first and the most significant problem of these states, and therefore no investor wants to invest in these states. So hate speech is a very problematic area that impacts your economy also. Then whenever I'm talking about the legal impact, so legal impact you can think from this perspective, that for example, how many of you know about the convicts of the hate speech? ऐसा कभी तुमने सुना है कि hate speech बोलने के बाद कोई जेल चला गया? Have you heard of hate speech? People are talking about the hate speech and they have sent to the jail. Conviction rate in the case of hate speech is less than 1%. Conviction rate in the case of hate speech is less than 1%. It means that people knows that even if they will give the hate speech, then it is not going to make a big change, that it is not landing up them into the jail. And this is the problem, that whenever the people are sure that there will not be any conviction, then how you can check the rising hate speech? So this is the problem of the hate speech. Now, hate speech may be इसी condition पे होता है, that is the security of the state is being hampered, public order is being hampered, there is a chances of incitement to an offense. देखो यही incitement, भड़काऊ भाषण, incitement to an offense. This is very important, that whenever you are whenever you are speaking anything or something, then what is the intensity of that, whether it has the potential to incite the offense or not. That is very important. Then the last one, that is the friendly relation with the foreign state. For example, the India-Bangladesh relation is going in a very good phase, for example, and तुम कुछ बोलोगे तो फर्क भी नहीं पड़ रहा है, मैं भी कुछ बोलूंगा तो कोई फर्क नहीं पड़ता है. So it is not going to make any change. But a person holding public position, a very distinguished position in this country, or a minister from this country, and if that particular person is telling something about Bangladesh, then obviously it will impact the friendly relation with the foreign state. And therefore, if any minister, any public official is tweeting something on the Twitter or writing something on the social media platform, anything like that, so then the government can ask, delete karo. Whatever you have written, delete that. Because it has the potential to disturb the friendly relation with the foreign states. So on that basis also, your freedom of speech and expression can be taken. And this is mentioned in the different laws that I told you. In the Telecom Act also it is written, that is the friendly relation with the foreign states. Now the question arises, the next one, that is the contempt of court. So obviously I will not discuss in detail about the contempt of court, but I am just telling you the basic idea of the contempt of court. Just suppose the court has given certain verdict. The court has given certain verdict and court is not accountable for any verdict. Uske man mein jo aayega wo bolega and they will not bother about its impact. So the court has given certain verdict. Now you are telling that I will not follow the court's order. You are directly telling to the court in the courtroom that I will not follow your order. So in that case, the court can send you to the jail. That is called considered as contempt of court, that you have done contempt of the court. Likewise, if you are trying to interfere into the administration of justice, it means that if you are trying to bribe the judge, so it doesn't mean that the judges don't take bribe, but you will have to understand that which judge is taking bribe and which judge is not taking bribe. So judge who are very honest, or breakfast table pe tum pahunch gaye 5 crore rupees leke. So in that case, he will consider it as an interference into the administration of justice. Then also it will be considered as contempt of court. Likewise, if you are writing something, anything, not something, if you are writing anything about the judge on your social media platform, in the newspaper, if you are writing anything about the judge, and if the judge consider it derogatory and defamatory, then in that case, the court will send you to the jail. It's not about the court, it's also about the judge. For example, if you will write in the newspaper that the judges are selling justice by accepting bribes. For example, if you have written something like that, then they can send you to the jail. And they have sent many people to the jail. ऐसे एक example बता देता हूँ, एकदम बेचारा हंसता हुआ इंसान राजपाल यादव. So Rajpal Yadav, there was one case with respect to him, that is the check bounce case. किसी को check दिया होगा, अभी सही से चल नहीं रहा है जीवन, तो check bounce हो गया. So now that is called a check bounce case. So what has happened? That the person to whom he has given a check was bounced and then he went to the Delhi High Court. Delhi High Court has asked Rajpal Yadav to present in the court. At that time, Rajpal Yadav was not in India. So he was busy, maybe, I don't know where he was, but maybe he was busy in some films and all. So he has not attended the court on that particular date. After 10 days, Rajpal Yadav came and asked the Delhi High Court that you have asked me for summon and I am present today. Delhi High Court has said that I have asked you to present 10 days back. Then what are you doing today? Go to the jail. 10 days jail. 10 days he was in jail. That is being considered as a contempt of court. That is, you have done the contempt of the court. The court has said this, but you have not accepted this. So that is called as contempt of court. At that time, you will not say that this is my freedom of speech and expression. I can say anything about the judge. No, because this is limited as per 19 clause 2. Now, जो तुम 8 element देख रहे हो, you are looking at the 8 elements here. In 1950, these were not 8 elements. Some of the elements have been added by first Constitutional Amendment Act. Some of the elements have been added by 16th Constitutional Amendment Act. For example, incitement to an offense, it was not there. Public order, it was not there. It was added by the first Constitutional Amendment Act. Sovereignty and integrity of India, friendly relation with the foreign state, it was added by 16th Constitutional Amendment Act. It means that the elements of Article 19 Clause 2 can also be enlarged with the time. So for example, tomorrow, if the government wants to add something under 19 Clause 2, then yes, government can do the addition. The government can do the addition. So the point is, whenever the government is doing the addition, then you can go to the court against the government. Now the court will decide that whether it is the correct or not.